Hello, everyone. I am Kia Fleurinord with Fleurinord Law, and I have my good attorney colleague here, Ms. Nikita Lamar of Lamar Legal Group. And today we are going to be talking to you about divorce and taxes. So as the holidays are approaching, we're getting towards the end of the year. A lot of people start thinking about some things that they've been thinking about all year, but maybe putting them in place and taking some actions towards accomplishing those things they set out. So, Ms. Nikita, let's start out with dialogue about just divorce, the process. I know there is an emotional component. I want you to talk a little bit about that. And then I'll get into the financial tax component so people understand that, there are consequences and based on the decisions that they're making during this process. So let's start out with you about with the divorce. Can you tell us a little bit about divorce, the process, when someone is first thinking about it, what they need to be thinking about when they contact an attorney?
Sure. Good morning, and happy to be here to discuss this topic. My name is Nikita Lamar. I am a divorce attorney and probate attorney in Houston, Texas. And you're right. This time of the year, people start thinking about how they want to enter into next year. And
Hmm.
sometimes, unfortunately or fortunately, you're thinking about changing your marital status from married to single. And so we get a lot of calls this time of year. This is the beginning, and people start hanging out with each other in during the holiday season, and they figure they don't want to do it again. So, um, okay, so divorce in Texas. Um, when you decide that you want to actually get a divorce, of course, the best thing to do is to consult with an attorney. And it's also nothing wrong with consulting with a few attorneys to see which one is the best fit for you. um, and in the beginning, you'll get your attorney, you'll talk, you'll give your attorney the information that they're requesting. They'll want to know things like how long you've been married, how many children do you have, if any, what type of assets you all have accumulated as a married couple. And which ones you had when you entered the marriage. In Texas, we are a community property state. What that means is anything that you accumulate during the marriage is considered community property. That means it belongs to both of you. And a lot of times it doesn't matter if one spouse's name is on it and the other spouse's name is not, or vice versa. A lot of times people think that that makes them safe. And a lot of times it does not. If you purchased a home during the time that you were married, that's considered community property, even if the husband's
Unless
name,
they, unless they have a prenup, correct?
unless they have a prenup, of
Okay.
course. If you have a prenuptial agreement and you guys have agreed that these certain items or things that you've already accumulated are just yours, then of course, but we're speaking on if you don't have that. If you don't have that and you enter into the marriage and you accumulate property, you may have purchased property, you purchase cars, all of those types of things, furnishings for your home, all of those things are considered community property unless you guys have stipulated that it's going to be considered a separate property, and that's usually done through a prenuptial agreement. When you visit your attorney, you'll talk about all of these things. You will then file your petition. Your attorney will file your petition. And in Texas, we have what we call a 60-day waiting period. And I just want to kind of talk about that briefly because that comes up sometimes. That only means that from the date that you file your petition, you have 60 days before you can actually go in and what we call prove it up, or for a judge to grant your divorce. And so that's just to give people time in case they change their mind. But once you file, then the process is started essentially. And a divorce is a lawsuit. So you do file a lawsuit against your spouse or your partner. And so it's a lot of things that come into that, but usually that's how things start. Sometimes we have um, emergency situations where a spouse maybe um, has taken money from an account and the other spouse can't access it. If one spouse isn't letting the other spouse see the children, those types of things we consider situations where we have to address that right away. And so you may have to go into what we call a temporary orders hearing in the beginning. It's a case by case basis. I've seen a lot of different scenarios. Some of these things can be amicable, some of them are not so much. But
Yeah.
essentially, that's kind of how you get started.
Hmm.
You establish your attorney client relationship first, and then from there, you let your attorney handle your divorce. And you guys of course, meet and talk about case strategy.
All right. So let's talk a little bit about the assets
Okay.
accumulated during the marriage. Um, I've had a couple interesting cases myself where, let's say, property has been inherited.
Hmm.
Now, we learned in law school, all of us, that
Right.
there's certain types of property that are not a part of the marital community,
Correct.
and inheritance is one of those assets.
That's
So
correct.
if someone passes in your family and they leave you assets, those are your separate property,
Correct.
so long as, important point, you
Right.
don't commingle those assets. So,
Exactly.
so
Exactly.
example, if you inherited a house from your grandmother
Hmm.
and you and your husband decide to move into that home, once she passed, you change the title. You change the title to just your name.
Hmm.
Remember, we said that a few seconds ago. That doesn't matter when you're married, whose name the asset is titled in. If it was purchased
Correct.
or acquired during the marriage, it's marital property or community property. Now, I'm also licensed in Florida. Florida is not a community property state, so that's why I have to use both terms.
Right.
So, community property it's a Texas term.
Correct.
Florida, we use marital property. So, if you move your spouse into that home and y'all have a happy life there, you live there, cohabitate in that home, and he considers
Hmm.
that or she considers that to be his or her home as well, homestead,
Hmm.
then talk a little bit about what happens um, as in terms of the homestead status and
Well,
divorce.
so
How does that?
just like you said, yeah, just like you said, when you start commingling, so if say for instance, if you're gifted something or devised, if someone gifts you something or you get it when someone passes away, but you pull your spouse into that situation, or you say for instance you get a check from your aunt who passed away and you deposit it into your community property account and you start using it for household things, or like you stated, if you move your spouse into the home and your spouse starts to then put money into that home, you guys may have to fix things on the home, you may have to buy things for the home. And so while you're doing all of those things, that's considered commingling of your assets. So at the time of the divorce, that's when everybody wants to say mine, mine, mine.
Yeah.
But we'll do tracing on it if it's an asset or something like that that is in dispute. We're going to see how that asset was used. If in fact the spouse set it up so that they were the only person who could use it, then those things would indicate that that's a separate property for that particular spouse or partner. But if you have situations like we're talking about where both parties are making use of it, it's going to household for household use. If you have a homestead and you are both contributing to that homestead, then that goes more towards that being a community property asset. And so at the end, you're going to have to, that spouse could say, okay, well, that is your separate property. However, I have a claim for what we call reimbursement. And essentially, what that means, and I won't go into because it can get very complicated, but essentially, what that means is that spouse can say, okay, that is your separate property, that is your home. However, I have put in X amount of money, and because of this, you're not entitled to all of the equity that's in the home. And so then we have, it's a numbers game, right? So we're either in mediation trying to come up with a number, or you're gonna end up before the judge, and the judge is going to make the determination as to how we're going to classify it, whether it's going to be separate or community, and if that reimbursement claim sticks. And if so, how much is that other spouse or partner entitled to?
Mm-hmm.
So it can, and I've seen it go a lot of different ways. Sometimes it's the way that a person thinks. Most of the times it's not. Because a lot of times people get hung up on whose name is on something. And when you're dealing with a state like Texas that is community property, a lot of times it goes out of the window, especially when you're talking about how those things were used.
Now, let me throw a little twist in here. Texas is also uh, so in addition to being a community property state, you also have where you can have an informal marriage
Correct.
or a common law spouse. Um, so if people are in that type of scenario,
Mhm.
is there such thing as a common law divorce?
Well, we, yes, yes, in Texas. So, um, common law marriage doesn't exist in a lot of states and in many states, but Texas happens to be one that recognizes it. Um, and you have to prove that you held yourself out to be married. You have to prove that there was an agreement to be married as well. A lot of times that's where people have the the greatest disadvantage when it comes to common law marriages that didn't last that long. Now, if you have a common law marriage that lasted 15, 20 years, I've seen it, it
Mhm.
becomes easier for you to prove. But you have to definitely prove that there was an agreement that you guys held yourself out to be husband and wife. And usually, how that's proven is through testimony. You may have friends and family. When people have jointly signed contracts with each other as they relate to buying a home, buying cars. If they used each other's one of the spouse's last name, if they held themselves out to be, we do recognize common law marriage in Texas. So yes, that's a possibility.
Okay.
Um, what I tell people is when they do that, I have them to understand that if something goes south, then the other person usually doesn't want to say that they were married. And
Yeah.
I've had a lot of those situations, not only in divorce, if you could believe it, but also in the probate arena.
Yes.
Because think about it, if a person is with someone, I had a 3-day trial about that not too long ago, where we had an individual who said that they were married to the other person. The other person passed away. There was no indication, hardly any indication that they the decedent, the person that passed away, intended to take this person as his or her, as his wife. And we had to try to prove it, and we could not, unfortunately.
Mm.
So, I tell people to be careful in those scenarios. Marriage isn't for everyone, though. But, when you decide to do those things, you need to have other things in place,
I agree.
to take care of that other individual should you pass away, like life insurance policies and things like that. Because what happened with this scenario was the family came in and tried to put her out of the home. And, unfortunately, at the end, she did have to move because it couldn't be proven that, this person intended to be her spouse.
Mm-hmm.
Yeah.
Okay. All right. So then that brings us to um, a little bit of a discussion about taxes. So
Mm-hmm.
just say um, this couple did extremely well for the past couple years. They didn't get around to filing their tax returns. And unfortunately, they have a huge tax bill for the past 2 or 3 years that they've been paying on. Then comes along this divorce. So under IRS rules, married filing jointly, you both are joint and severally liable for this tax liability
Mm-hmm.
and for most liabilities during the marriage.
Yeah.
So can you talk a little bit about maybe if there's some sort of negotiation as a part of the settlement agreement,
Mm-hmm.
or um, if one spouse agrees to take on the debt while the other spouse agrees to take on the mortgage? Um, can you talk a little bit about important key considerations during the negotiation process as
Sure.
it relates
So
to those items?
Sure. So usually when we have those discussions and we're working through that, typically is during mediation, right? And
Okay.
so what people don't understand is most cases, not just divorce, but we're talking about divorce today, but most cases are settled in mediation. It's only a small percentage of cases that actually go before the judge for trial. As attorneys, we see it because that's what we do. But when you look at the majority of cases, they're settled in mediation. And so during mediation, we not only talk about how we're going to separate the assets, like the home and the cars and all those types of things, IRS accounts, we retirement accounts. That's what I meant to say. We also talk about how we're going to split liabilities, and we do talk about if there are any tax debts, if there are any household debts that are outstanding, credit card debt. We do talk about all of those things, and usually those are the bills that are a bit, on the more expensive side. Like if there are
Mhm.
any taxes that haven't been paid, if there are any taxes that have to deal with the home, property taxes. We talk about all of those things, and that's the negotiation that you're talking about. Usually, we're talking about that in mediation, and when you're in mediation, if you're able to reach an agreement, then that mediator, who's typically an attorney, will draft what's called a MSA, which is a mediated settlement agreement. And if you guys come to an agreement, all parties will sign that mediated settlement agreement. And that becomes the beginning of the finalization of your divorce. And
Okay.
so that mediated settlement agreement will speak to who's responsible for what. And usually we try to put timelines on it. If they're time sensitive, especially if you're talking about property taxes and things like
Mhm.
that, then we
Mhm.
will put a deadline on that to ensure, hopefully, that the other party will, do their part and pay what they're supposed to pay. Now, that doesn't happen all the time. And so we end up in court on post judgment, matters because someone didn't do what they were supposed to do per the MSA. But from that MSA, one of the attorneys will draft your final order, and that's typically a much longer document.
Mhm.
And so your one of the attorneys will be responsible for that. But that's typically where we're talking about those matters.
Okay. All right. And so also during that process, if the couple owned the home
Hmm.
and come to an agreement to allow one spouse to keep the home, the other spouse, maybe they buy them out.
Right.
Um, a key consideration that I've seen a couple times from a tax perspective that a lot of divorce attorneys do not warn their clients about
Hmm.
is the capital gains tax
Hmm.
on this asset. Now, at the time of divorce, most people are not thinking about selling that home. So it doesn't, it's not relevant in that moment.
Hmm.
But I've had a client specifically, happened to be the wife. She bought out her husband, and it was, in this case, unfortunately, she was an attorney. and she didn't hire a divorce attorney.
Oh,
So
okay.
it was an amicable divorce.
Mm-hmm.
You know that old saying about an attorney that is his own client?
Oh, yeah. Yeah.
How does that go? How's that saying
I
go?
well, it's something like, only a fool represents themselves or something like that. But
Yeah.
I totally agree. I think in certain instances, if it's a traffic ticket or something like that, sure. I've done it. You go in, usually you talk to them, they know your attorney, you can take care of it. But larger matters, if I had a divorce to go through, I would not represent myself. And you
Even though
spoke.
you're a divorce attorney.
Oh yeah, for sure. Because like you said earlier in the beginning, it is an emotional thing, even if it's amicable. Something is coming to a close in your life. Things are
I mean,
changing. Your head is everywhere. I just wouldn't do it. But yeah, I know a few people who have represented themselves, and most of them that I know, it's only a handful, have said that they wish that they had not.
yes.
Yeah.
So in this scenario, um, the wife, let's say she bought the husband out for 300,000. They
Hmm.
had an appraisal done. The house was worth 600,000.
Hmm.
She bought him out for 300,000.
Hmm.
Then 300,000, no taxes, just outright
Right.
cash.
Hmm.
10 years later, the house appreciates to $1 million.
Hmm.
And then she's ready to sell because she wants to relocate and go move to a different state.
Yeah.
So guess what? They bought the house 10 years prior to the divorce for 200,000.
Hmm.
Guess what her capital gain is? $800,000.
Yeah.
$8,000 capital gain.
Yeah.
Now the tax rate on capital gains is typically 20%.
Mhm.
So 20% of that $800,000 has to go to the IRS as a part of the
Mhm.
capital gains tax.
Mhm.
But she was the only owner at the time of the sale.
Mhm.
So she is liable for the what's 20%. So that's $160,000
Mhm.
capital gains tax that she's solely responsible for. But meanwhile, her ex-spouse walked away with 300,000 tax free.
Mhm.
And so something that I want a lot of divorce attorneys to think about, and people who are married, when you're making that decision, make sure you consider the taxes.
Mhm.
So he should have been liable for 20% of that 300,000 that
Mhm.
he got outright.
Mhm.
He should have been able to have that as an offset during the settlement agreement.
Mhm.
Um, but if it's a $2 million home and you bought it 20, 30 years ago, I mean,
Mhm.
just imagine how the tax bill grows when people don't think about that. And especially divorce attorneys, they're not tax attorneys, they're divorce attorneys for a reason. They don't think about that. But I think I need for a lot of our divorce attorneys to emphasize or require that their clients seek counsel from a tax attorney or a
Mhm.
CPA so that they can break down what the tax implications would be right now and potentially down the future.
And I definitely understand, where you're coming from. Now I'm gonna tell you, candid, candid conversations. Um, Usually, if that's gonna occur, is it's usually gonna be people with a higher net worth, or people who have more, because a lot of times when we look at, you know people who are, I don't like using the term working class, but I just say that because I just say, people who go to work every day, and they were able to buy a home together, and they have kids in college, and they don't have a lot of disposable income. A lot of where their um uh financial stability is maybe in that home that they
Mhm,
purchased, because they have equity. It when you look at coming to an agreement in mediation, which a lot of people do because they want to save money as well, because
mhm,
going to trial is expensive. even if
Right.
you're going to trial on just one thing, one matter, even if it's just about the property division, it still is expensive. I think where the breakdown is um, in that moment, because I think maybe people who understand capital gains or understand about how that's going to be taxed on the individual later, maybe they don't bring it up sometimes because they think it's going to blow the mediation up. You know, I don't know, but I
That's a,
think that that's something to consider. So, maybe bringing in a tax attorney or CPA during mediation, could be a good idea,
mhm.
as opposed to having them to go outside, of, because a lot of clients won't do it. Some of them
Yeah.
will, but a lot of them won't. But I think it's a good idea to start having those tax conversations during the time of mediation, for sure, and to see if it will, sometimes it may derail it because we're talking about something that's going to happen in the future. Because, like you said, a lot of times when we're going through this, the spouse that wants to stay in the home isn't thinking about selling the home right away. If they're both thinking about selling the home, then that's what we're talking about in mediation. We're talking about selling the home, and we have agreeing on a realtor, and having that realtor to have them to agree on a listing price, those types of things. But I definitely think it's a good idea to bring the tax conversation in about these things, because I know earlier on when I started, it wasn't something that we thought about. Recently, through conversations with you, I have started thinking about that. But I think that sometimes it's not that the attorneys don't know. I think that they're thinking about, conversations that may derail, or things that may or may not happen in the future, because you don't know whether or not you're going to sell. But I do agree that those are things that we should start thinking about or considering, in the future. Is are those things, and maybe if it's not a 20%, you're just negotiating a lower price based on the fact that when I sell this, I'm going to have to pay this additional cost. So I do agree that the mediation would be a great place to talk about it, as it relates to the division of the property.
Okay. Now let's get into a quick discussion before we run out of time about alimony and spousal support.
Okay.
So I know Texas does not have alimony, which
No.
I am a fan of that law. But um, I'll just say very quickly from a tax perspective,
Mhm.
alimony, spousal support is not tax deductible for the person who's paying it.
Mhm.
If you were divorced prior to December 31st, 2018, you probably were able to deduct that on your tax returns. But there's a new law out now, and domestic payments no longer tax deductible. So if
Mhm.
you've gotten divorced after December 31st, 2018, and your divorce was final after that date,
Mhm.
no tax deductions there. But can you
Okay.
talk a little bit about the negotiation process, things people need to be thinking about? I know there's not alimony in Texas, alimony in Florida, but talk about
Yeah.
it from a tax perspective and the spousal support.
Yeah, sure. So you're correct. We do not have alimony in Texas. And I know a lot of people are very happy about that. But we do have what's called spousal support. And typically, spousal support can last anywhere from, 3 to 6 months, all the way up to 10 years. It's a long list of things per the family code, the Texas Family Code, that courts will use when they consider, or factors that they will use when they consider whether or not to grant spousal support. Some of those things include the duration of the marriage, um, if there were any disparities in education when it comes to one spouse versus the other, and we look at that as it relates to earning potential. You may have someone who is an attorney, like us, and they have the capability of going out and hanging their own shingle, or getting a job maybe at a firm or something like that, versus if you have someone who was maybe a stay-at-home mom, maybe she didn't go to school, or if she went to school, maybe she got a degree that she never used because she was at home. We look at earning potential. We look at whether or not there were any disabilities. You might have a spouse who has a disability that would prevent them from being able to find employment or even working at all. We think about the court considers a lot of different things when we talk about spousal support. Those are just some of the things that they will look at, and so and that's to cover individuals who they may have come to an agreement during the marriage that one spouse was going to stay at home. We see that a lot.
Mhm.
People talk about it in terms of a stay-at-home mom, but we have fathers who opted to stay at home and take care of the family because the uh, the mom is the one that had a more lucrative career.
Mhm.
And so we see both of those things now. So in those instances, the court does want to lend some protection to that individual who made a decision, because that is work, correct?
Yeah,
Like, that is work. Taking care of your family, taking care of children, that is work. And people don't
absolutely.
want to quantify it, but it's absolutely work. And so in those instances, the court does want to make sure that that other spouse can't just, um, yank the rug from under that individual and say, well, no more money for you. Everyone knows that they're going to have to figure out a different way of life, but we do have spousal support in place for those types of situations.
Okay. Now, speaking of uh, the home life, being a stay-at-home mom,
Hmm.
um, let's switch into a discussion about child custody,
Hmm.
um, child support, and claiming the children as dependents on the tax return.
Hmm.
So I just want to talk really briefly. Child support, not tax deductible. I don't think it has ever been tax deductible from a moral or rationale standpoint. It's your obligation to care for your children financially, emotionally, mentally, educationally. When you decide that you want to have children, or maybe you didn't decide and maybe you had a oops unplanned. Either way, the law says that that's your obligation. You're required to take care of that child. Child support is not tax deductible. I don't think it has ever been tax deductible. Um, when we get into uh, claiming the child as a dependent on the tax return, I strongly recommend you include those terms in your settlement agreement or divorce decree, so that there is no misunderstanding and you think it's your year to claim the child and your ex-spouse claims the child before you do, and then now you got a big mess with the IRS. So can you please, 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 please talk a little bit about child custody, child support, and claiming the children as dependents while they're still minors?
Yes. So we do, I do include um, a section in the MSA and or the order that discusses which parent will uh, be able to claim the child on taxes. Normally, we all do. Sometimes it slips through the cracks, but typically we do have something in your mediated settlement agreement and or order that talks about that. And typically, it's going to be the parent who is the joint managing conservator with the right to determine residency, or sole managing conservator. And we have, both here. And joint managing conservator with the right to determine residency is the parent who determines where the child will be living and going to school and usually making a lot of the day-to-day decisions. Sole managing, when you have a sole managing situation, the other parent then has possessory rights, which means they're just going to have visitation. And that sole managing conservator is the person who typically would claim the child on their taxes. And as far as child support, Child support, we have to discuss that. If there are children that were born of the marriage and there's now a divorce, then we definitely have to discuss um, not only who's going to be responsible for what, as far as rights and responsibilities and roles, which is the custody. We also talk about child support. And typically, the person that's going to be receiving that support is the joint managing conservator with the right to determine residency, and or the sole managing conservator. They're going to be the ones to take payment, from the other party for the children. It's for the support of the child or children. And so we do discuss those things in our mediation, or the judge, will make that determination if we are not able to reach an agreement. And I'm gonna say something about child support that a lot of people don't understand either, is that it's really no getting away from that responsibility. A lot of people, try to find ways to get around it, but you really cannot. If you owe that money until or unless you have an order that says otherwise, then you owe that money. And unlike a lot of other creditors, they can reach a lot of different places, including sometimes trust accounts. When people have trust open, they think that that makes them safe, and it doesn't all the time. You will have to pay that money, and a lot of times people get away with it because the parent who's owed that money, they don't pursue it. Sometimes they don't know that they can. Believe it or not, they think that it's no way, but you have to hire an attorney. But post judgment cases happen all the time. So after you're divorced and you have your order, somebody violates that order, which would include not paying the child support, you do have an option for an enforcement action against that other party. And a lot of times we see those enforcements either by the office, the OAG, the Office of Attorney General, which that's the office in Texas that deals with child support matters, or you can hire your own private attorney to come in and file that enforcement against that individual. But typically that's how we handle child custody and child support, in divorce.
All right. And so then lastly, let's talk about maybe a retirement plan or 401k plan that the spouses or maybe just one spouse has built up
Mm-hmm.
during to the marriage. And you're negotiating who's entitled to receive that, the payments or the withdrawals or distributions.
Mm-hmm.
From a tax perspective, um, if you receive a lump sum of anything, you're going to pay income tax on it unless it's a Roth IRA where the value has built up over time and it's post tax, meaning post income tax. So when the withdrawals are taken, it's tax free.
Mm-hmm.
But in a divorce context, if the spouses have negotiated that, let's say one of them was a stay at home and then the other spouse kind of built up, I don't know, $1 million in
Mm-hmm.
this. Hey, they've been married for 30 years and his whole career or her whole career, she's built up $1 million. Husband was stay at home father with the children.
Mm-hmm.
Um, Typically, how do you manage that? Like, have you seen it where the non-working spouse kind of agreed to take a lump sum or half, and
Oh yeah.
where they decide to delay, and then once they reach the retirement age, that's when they start drawing payments on it? What has been your experience, or what have you been exposed to during your career as a divorce attorney?
So I've seen it go a lot of different ways, but I'll just discuss usually how it goes.
Oh,
So in those situations, during the time that we're discussing these matters, like I said, typically it's during mediation where we're trying to come up with an agreement as to how this is going to go. Um, Let me just say this. We talked about Texas being a community property state, and that does include your 401ks, your pensions, things like that. Now, it's only during the time that you were married. So, say for instance, you've been working with the company for 20 years. You've been married 10 of those years. Only those 10 years that you've been married, that what has been accumulated during that time is what's on the table.
Okay.
Before that is yours. That's
Okay.
separate property. It's no ifs, ands, or buts about it. You weren't married, so that they can't touch that portion. So then, of course, there's some calculation that has to be done to figure out how much of what's in your retirement was accumulated during the time that you were married. So that's what we're talking about. That's usually what's on the table during that time. So when we're discussing those matters, I've seen it go a lot of different ways. Typically, especially with pensions, because you can't touch that money now. Usually we talk about um, once a person retires, what that's going to look like. Sometimes people don't want to wait that long, so they say, "Well,
Mhm.
I'll take a larger amount of the 401k then, and I'll leave your pension alone." I've also
Mhm.
seen it where we discuss we use it as leverage sometimes,
Mhm.
and we'll say, well, we'll give you more equity out of the home if you leave this pension where it is,
Mhm.
or the 401k, and typically we'll have what's called a qualified domestic relation order, a quadro that will be drafted afterwards,
Mhm.
that will address how we're going to split um, your 401k, or your pension, or whatever type of retirement plan that you have. Usually that's what happens. When we're discussing these matters, like I said, it can go a lot of different ways. And a lot of times people use those numbers as leverage, and they may give from another portion of the community estate, or even their separate property sometimes, so that they can retain, as much of that as possible. I've seen it too, where I've had people who were what we call evenly yoked. Their 401ks, their pensions, they look similar. So they
Mhm.
just make a decision to just leave it alone, because
Right.
essentially you're going to be getting the same amount of money, from the other party. So I've seen it go a lot of different ways, but the negotiation of all of that is definitely done um, via mediation, and if you're able to reach an agreement, that's great. If not, then someone else, a judge, is going to make that determination as to who's going to get what. And typically, that's not what you want, because you don't know how that's going to go. In mediation, you both have some type of say as to how this is going to go. So, I always tell my clients to try to come in with an open mind, and understanding that nobody's going to get everything that they want. Typically, you're meeting in the middle.
Right.
Yeah, to try to come to an agreement, so that you're not spending 10, 15, 20, 30,000 extra dollars on both sides in order to
And that's
have
legal
someone else.
fees, right?
Oh yeah, that's legal fees.
Yes.
In order to have someone else to tell you what's going to happen with your money, and sometimes we can't. Sometimes we just can't reach an agreement. There've been, certain situations where there's a lot of money at stake, and people were just stubborn, But being stubborn sometimes can cost you more money than not. So
Oh yeah.
it depends on how you want to play it.
And I don't know an attorney that's not gonna take their fees and
I
they've
mean,
earned. You're not
that's
gonna
what
get
you
a
pay in
discount because you
the
want to be stubborn.
correct, correct.
Okay, so final point that I want to make very clear to everyone, and speaking of retirement plans and 401ks and pensions,
Hmm.
you designate a beneficiary when you usually start the job.
Hmm.
You fill out a form, you decide who you want to get those assets should you unexpectedly pass away.
Correct.
Now, you may leave a will that says, I want my retirement or my 401k or pension to go to my children.
Hmm.
Well, spoiler alert, that's not going to work under the ERISA laws. So if you that's what we consider non-probate property or
Yeah.
non-probate asset,
Hmm.
meaning that your will cannot dictate who gets the asset outside of that beneficiary form that you filled out. And if you forget to change the beneficiary from your ex-spouse to your new spouse or your children, it just slips your mind. You don't think about it. You live for another 30 years after the divorce. You never thought about changing it. Guess who's going to get that retirement plan, pension, 401k if you pass away before you change the beneficiary? I'll let you
So,
do the honors, Miss
so listen,
Lamar.
I do have a story, and no names, of course, but that exact thing happened. Had a very contentious divorce. I mean, extremely contentious, very emotionally draining for all parties, and came to an agreement. The one of the spouses, I'll just say that one of the spouses passed away shortly after. I'll
Mm,
say not even a year, maybe
wow.
5 months during the time where we saw a lot of people passing away during COVID.
Mm.
And
So that was
that
probably unexpected at that time of the.
it was very unexpected because this person was in seemingly decent health for, someone their age. And so that happened, and that happened to be the spouse that was the loudest, the meanest, and forgot to change beneficiaries. So on a lot of things. And so the other spouse ended up getting all of the money that they settled for back, and the money from those all of those policies that that person neglected to change beneficiaries for.
So that's
And
for life insurance, a retirement account.
it was about, I don't know how many there were, but there were at least two or three. And that's not talking about bank accounts and all this. It was just, it was very interesting, to say the least,
Wow.
how those turn of events happen. And I found out about it, probably almost a year after, when I spoke to someone. But that can absolutely happen. And
Now let's
so
let's talk about the divorce revokes rule.
mhm.
So what assets does that typically apply to outside of life insurance, retirement accounts, bank accounts
Well,
where you
bank
designate?
accounts, those are the ones that I was thinking of. Those are the ones that I know about. That in this particular situation where they have, they neglected to change beneficiaries, and the person was still listed as the beneficiary, in those spaces.
Mhm.
So, what I usually recommend is, even before your divorce is finalized, start thinking or draft a list of all your policies and things like that. And including your will. It's good to change your will. Now, they have some things in place as far as the state's code that may add some protection for, persons who may have designated their spouse as an executor or executrix on their, in their will. But on the flip side, we're just talking about, the divorce aspect of it, not as many protections. So whoever you have listed as the beneficiary, that's typically who's going to receive those funds. So I start telling people, think about the things, not only your name that you want to change, but start thinking about those policies and that will and all of those things that need to be updated once you are divorced.
All right. Well, Miss Nikita, I thank you so much for your time this morning. I think our followers are going to learn a lot from this discussion we've had. Can you please tell the people how they can reach you? What's your social media handle and your office number and your website so they can get in touch with you if they need to?
Yes. My website is Lamar Legal Group. That's my last name, LAMAR Legal Group, all one word, .com. You can find Lamar Legal Group, PLLC, on Facebook as well. My office number is 832 767 1976. So feel free to contact us. You can actually book if you need a consultation, you can book that on our site, on our website. And if you need to call instead to book the consultation, feel free to do that at the number that I gave. But we're happy to assist.
All right. Well, thank you so much. I really enjoyed it, and I look forward to our next one.
Yes, thank you so much for having me.